This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about grandpa in the law. We're talking about estate planning, wills, trust, what kind of documents you need, powers of attorney, things like that. You know, it's time to prepare for the future. If you don't have a will and don't tell the state how you want your assets to go when you pass away, the state will have a plan for you and it may not be what you want. So tonight's your chance to call in and ask some questions, or if you feel like you're too young for that, you probably have some questions about what your parents ought to be doing. So call in the 31 Law Call number 256-536-0077. You can also email. You can email anytime, any day of the week on any legal topic. You send it to lawcall@waytv.com. And when we get to a show that's on point, we will pull out some of your email questions. And we've got some of your email questions tonight. Michael Timberlake's here from Timberlake and Lee. Good to have you here.
Well, it's good to be here.
We have got tonight's You Be the Judge Law Call video. We pulled some video off of YouTube, and it's always interesting because it fits into your area, which is personal injury kind of cases. Okay, tonight we've got something on the highway. It looks like some folks that are racing. Okay, hold on. There's going to be a yellow Corvette come up on the left-hand side.
This is off of 565.
I don't know that it is.
No.
Look at all that. These folks are racing, and I think they hit a third vehicle that's over on the side. So how does all this figure in? If the yellow car, the yellow Corvette, is not the one that's part of this initial accident, they didn't cause it,
right,
but they are racing. Who's at fault here, and how does that play into figuring out a case with something like this?
Well, I mean, you know, clearly in this situation you've got, you know, at least, you know, one wrongdoer, and it looks like you have more than one wrongdoer. Yeah. In Alabama, Alabama law provides that you can have joint and several liability against co-tortfeasors or against two people that are doing something wrong. So in this situation, you basically have a case against both drivers because they were combined and concurring in acts that would cause you injury and ultimately did cause you injury. So that's you know, the way the Alabama law says that, you know, if they're both contribute in any way, then they are both liable for the entirety of the damages. You don't apportion it between the two people. You just say, here are my damages, y'all figure out how to pay them.
Wow. Okay. Tonight it's Grandpa in the Law, which is all kinds of estate planning sort of questions, and you brought a great expert with you.
Right, we brought Connie Glass, who's our elder law expert. She does this on a daily basis and does a great job with it, and we're very, very pleased to have her again on the show.
Thanks. I'm so glad to be here.
Thanks for
Appreciate
coming.
the invitation.
Connie's just found out she's going to be a grandma. I have to toss that out there. Yeah,
that's
congratulations. We're thrilled for you. Thrilled for you. Okay, Grandpa in the Law or Grandma in the Law. What are some of the basic estate planning documents that everybody ought to have? Everybody.
Well, we tell our clients that there are 4 things that you really need to do. You need to do something as far as disposing of assets at death. You need a will. Very basically, you need a will. A lot of people want to look at trusts, but for many people, a will is going to suffice. You need powers of attorney both for financial decision making and medical decision making should you become unable to make your own decisions. Who's going to write your checks and pay your bills and make sure the lights stay on? Who's going to talk to the doctors if you're sick? Who's going to authorize surgery? And then the final document that we do for clients is the living will, the advance directive for health care. That's the document that says what you would want done in the event that you're terminally ill or injured. If there's no hope of recovery, would you want to be sustained, or do you want to die naturally without any artificial means used to sustain you through that dying process?
It's not a fun process to plan these things.
Not. I don't talk about fun things, but we talk about important things.
Yeah.
Things that it's going to happen to all of us, and we need to plan ahead.
My husband and I have been talking about doing these, and you start judging your family members on who's been good to you and who's not, but it needs to be done.
Well, it's absolutely, and I listened to something the other day on the news about somebody that was an attorney that did a lot of estate planning, and they said, well, you know, used to be it was the clients were kind of reluctant to come to us. It was, you know, they had some kind of life event that occurred that made them, you know, finally take the steps that they need to make for their future. But they said after the pandemic or after people had been exposed to COVID and were, you know, concerned about, you know, terminal illness and fatalities and catastrophic types of injuries, they're across the board. You've seen many more estate planning attorneys get a lot busier, and people will come to them without being coached. And so it's a good thing. I think it really is. Everybody needs to make sure that they plan for their future, because it's going to happen regardless of whether you want it to or not.
It's a great point, Michael. It's just during COVID, there were so many decisions that had to be made about care for people who were in the hospital, and so many of those folks did not have any sort of directive or agent to make those decisions. So I think that caught a lot of people off guard and by surprise, and you're exactly right. It's causing people to start to think about those issues.
And some of these, tell us which ones of these documents, you can do them again. Right, if you do it and you change your mind, you can just redo it.
Do any of them. Yeah, you can do them as many times as you want.
Okay.
Right.
What documents can you not undo? So I'm thinking of things like deeds, and sometimes that is part of estate planning, right? To change a deed, and that you can't necessarily undo.
If you deed your property, any part of the property interest to another person, then you can't change your mind and change that. It requires all of the owners of the property. So if you end up deeding your property to your children, just reserving the right to live there, it's called a life estate, then your children will have to join in with you in changing that. You can't say, change my mind, I want that back. They have to agree to that. If one of them dies, then their heirs are going to have to agree to that change. So that's a more long-term decision that you can't necessarily take back. Gotcha. Wills, powers of attorney, living will, you can always change those.
Gotcha.
As long as you're competent.
Okay. We've got callers waiting. Howie's on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, I have a long-term care policy with an insurance company,
okay,
but it doesn't kick in until 90 days have passed. And I also own some rental property, so I will not qualify for Medicaid. If I have an emergency and I have to go to a nursing home, do I have to wait until I can sell the property off in order to get into a nursing home, or will these places take it with putting a lien on and then sell it after the 90 days kicks in?
Interesting.
Yeah, I mean that's a good question, because if for a private pay patient that's looking at a long-term care situation, you're not going to have a government entity like Medicare or Medicaid back it up. Medicaid will typically, or Medicare, if you're eligible, will typically pay for a 21-day rehabilitation stay following a hospitalization if you need to go to a long-term care facility. So there's some time typically that you have a way to make some arrangements for plans. But in terms of becoming liquid, Connie, what do you do if you need to pay for long-term care immediately?
If you have a 90-day elimination period on your long-term care policy, that means that you have to pay for the first 90 days of care. So like Michael said, if you have Medicare coverage that covers maybe the first 20, possibly you have another insurance policy that might pay copays under Medicare, you might have a little bit of time that's covered, but you're going to have to come up with that 90 days of care. The nursing home's not going to take a lien on your property. They want a check. They want you to pay for the first 90 days. Most nursing homes in this area are around $10,000 a month, somewhere between 8 and 10. So you're going to possibly have to pay $30,000 to the nursing home before your insurance kicks in, and your property's not going to stand for it. They're not going to take a lien for that bill. You're going to have to pay it. So if your family has to sell the property to pay that $30,000, that would be what would have to happen.
So for somebody like Howie to plan ahead for that, if he's sick enough that he needs to be in a nursing home at that point, he's got to have a family member that's going to be able to do that business, right?
Yes,
so
exactly right.
What does he need to have in place?
That's the power of attorney.
Yeah.
That's the durable power of attorney.
Gotcha. Okay. We had a caller call in and say that she's dealing with a situation with a will where it turns out all the beneficiaries have already passed away. So does a will like that need to be probated?
Yeah, that's a really good question, and up until recently, I would have said no, because if if everybody's predeceased, it would just go to their heirs. But I mean, the will would have to be probated, but it would typically go to the decedent people's heirs, but that's not necessarily the case, is it, Connie?
Not necessarily. Before you even look at the will, the first thing you've got to determine is, are there probate assets? This is where everybody gets confused. If the person who died had no assets in their name only, if everything they have is either jointly owned with another person or has designated beneficiaries, then the will's not probated anyway because there's no assets that are controlled by the terms of the will. Let's say the decedent had a piece of property in his name or her name. Yes, the will needs to be probated because the will generally names an executor. Now, if the executor's dead, perhaps there's an alternate executor. And like Mike said, it's certain people that you name in the will. If you've named your children as beneficiaries and your children predecease you, then their share is going to pass according to that will to their children. The will may say something different. The will may say, if all of my children have predeceased me, then I give my assets to the University of Alabama or my church or wherever. So you've got to first look at assets, then you've got to look at the terms of the will to see what needs to be done.
Gotcha. They're telling us to take a break. We're going to take a break. If you've got a question tonight, call in the 31 Law Call number, 256-536-0077. More about Grandpa in the Law. We're answering your questions about wills and estate planning tonight. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're talking about Grandpa in the Law. So we're talking about wills and estate planning and those kind of issues. We've got with us Michael Timberlake from Timberlake and League. They are personal injury attorneys, so sometimes they bump into these same kind of issues. And Connie Glass from the Elder Law Firm, and she deals with this kind of question all day, every day. So we've got callers waiting with questions. Rita's on the line with a question from Paint Rock. Hi, Rita. Thanks for waiting. What's your question tonight?
Hi. I have a friend that has recently had to put his father in the nursing home.
Okay.
And his father's property, home and property, has a mortgage on it still.
Okay.
And so he was concerned as to whether the Medicare, Medicaid, whoever, will put a lien on his father's property.
Okay. Connie, talk us through this. How does it get figured out?
Okay.
And Rita, does your friend have a mother also? Is there a mother still living in that house?
No.
Okay.
No, she's...
In case that matters. Good.
It does matter.
Okay.
Thanks, Sharon. So when a person enters the nursing home, their obligation is to the nursing home is to pay the bill. The nursing home doesn't go immediately to, oh gosh, we got to take a lien against the property. That's not what the nursing home wants. The nursing home wants a check. So they send you a bill, you pay the bill. If you can't pay the bill, that's when you have to apply for Medicaid assistance. Medicaid looks back in your financial history for 5 years. What they're looking for is to see what assets you've owned and if you've given away or transferred something for less than its value. If you have assets, if you're single and you go to the nursing home and you've got assets in your name, money in the bank, stocks, bonds, CDs, whatever, you've got to use that up first, paying the bill, before you can qualify for Medicaid. So all of your assets have to be spent down to $2,000. If the only thing you have left, all your money's spent, the only thing you have left is your home, then Medicaid can approve you, assuming no gifts or transfers, Medicaid can approve you, and they will take a lien against your home place property. Now the issue with that is there's not going to be money to pay the mortgage payment. So if there's a mortgage on the property, more than likely the gentleman needs to sell that home. All of his income is going to have to go to the nursing home, and even though Medicaid's going to take a lien and start paying the bill, the mortgage can't get paid because all of his income is going to the nursing home. So in situations like that, we tell the families, you need to sell the property. If there's equity in the property, put the money in the bank, pay the bill, then apply for Medicaid assistance. So
What about here if mom is still living in the house?
if mom is still living, then the home is excluded entirely. Medicaid just ignores it. They act like it's not even there. So mom then would be responsible for paying the mortgage out of her income and any portion of her husband's income that she got to keep.
Good. Glad you're here to answer that.
Right.
Tracy's on the line with a question from Madison. Hi, Tracy. Thanks for calling. What's your question tonight?
Hey, thank you for taking my call.
You bet.
I have a question regarding these online services that offer, wills where you can go in and answer questions and it'll pretty much auto-populate that for you.
Sure.
So if I go and fill that out and have it notarized, is that a legally enforceable document in Alabama?
Well, the short answer to the question is it can be a legally enforceable document in Alabama, but you don't know until you talked with a lawyer that knows what they're doing in Alabama and can tell you the effect of what you have signed. Simply because there are certain words that say things that you have, and signed underneath it, and it's notarized, or you have two witnesses, may mean that you've done something, but trying to interpret what you've done without the benefit of a lawyer's advice in the state where you're doing it can be problematic and will likely end up costing you or your family more money in the long run. So, Connie, undoing these things is a lot harder than doing them, right?
Yes. Sometimes it would be better that the person died without a will rather than an online will. And I'm not telling you that all online wills are bad. It's just like Michael said, there's some decent programs out there. What you're missing with the online will is the knowledge of what that will needs to do for you. Everyone's estate plan is unique. Everyone's situation is different. There are some people who have children they need to plan for. Some people have disabled children. Some people have a spouse and they have children from previous marriages. They have a blended family. It's critically important when you're doing a will for your lawyer to know how your assets are owned, because that's going to take precedence over the will. Joint ownership takes precedence over the will. Designated beneficiaries take precedence over the will. So those online programs can't have that discussion with you. So that's what you're missing there. It's not the document itself. It's exactly what Michael said. Is that document doing what you think it's doing? It's doing what you need it to do? My short and quick answer to folks when they ask me about online wills is yes, you can also learn how to take out your appendix online, but I wouldn't recommend you do that either.
It seems like it would work though. So Michael's got a spouse, I've got a spouse, you got a house, I've got a house. It seems like if I took a copy of his will and I just changed the names, I could sign it and his ought to work the same as mine. But it doesn't work right.
The will does work the same, but let's say that one of you's in a blended family and Michael's will, let's say, Sharon, you're in a blended family situation where you have children from previous marriage, your husband has children, and I know that's not the case, but let's assume that's the case. So Michael's will might say, I leave everything to my wife and then my children. If your will said that, then your husband's children will be totally omitted if you die last.
Gotcha.
And vice versa. And that's usually not what blended families want. Right. If you leave everything to your husband, and then he survives you, then his children will get everything.
And my kids get nothing.
And your kids get nothing. So.
And the other thing that an online lawyer can't do or an online computer program can't do is look at your other assets and the way they're held. Is like Connie said, if they're held jointly, if they're held with a named beneficiary or a joint bank account, something to indicate that the property, the assets are going to pass outside of the estate. So you don't even have to probate a will. That's all going to be something that a lawyer is going to be able to look at and take into consideration when they are determining, what you want to do with your property that is remaining. So it's not just filling out a form; it's planning. It's estate planning, in addition to designating who gets what.
Well said, Mr. Timberlake.
We've got Butch on the line with a question from Ardmore. Hi, Butch. Thanks for calling. What's your question tonight?
I got some property,
okay.
And when I bought it, I put it in my son's name.
Okay.
And he passed away.
Oh, I'm sorry.
And what I've done, I made him sign I don't know what you'd call it, a paper, where I have a lifetime residency on the property.
Okay.
All right, and what I was wondering, if I move, and I've got a mobile home on it, if I move that mobile home off of it, will I still have assets to the property?
Interesting.
He had children, but they was young. They're young.
Okay. Connie, did you hear that?
I did, and it really will depend on what the deed says. With real estate, the deed is what controls, not extraneous other things that you might or might not have signed. But if the deed that when you bought the property, if the deed said that the property belonged to your son, subject to your right to live and use the property for the remainder of your life, then that's a life estate, and you would have control of the property while you were living. If the deed does not give you that life estate, then you don't have an ownership interest. The property would belong to whomever his heirs are. So without seeing the deed, there's no way any lawyer could tell you who owns it at the moment.
Interesting. Okay. Tyrone was on the line. He had a question. We're running short of time. Let's see if I can ask his question for him. Do you have to probate land? How does land pass through a will? Does that have to be probated?
I mean, it's basically what Connie said, was talking about that you look at the language in the deed. A property can be held jointly with right of survivorship, which means that two people own it, and when one of them passes, it goes to the other one. And that's just an automatic process, and that doesn't have to go through probate court. But if there's not a survivorship deed, or both people have expired, Connie, what happens then?
Then the property would become a part of the estate and be controlled by the terms of the will, and the will has to be probated in order to be valid.
What if you've got land in other states? Do you do it all in Alabama?
You start in Alabama, then you do what's called ancillary probate in each of the states where you own property.
Gotcha. We're going to take a break. Be right back answering more of your questions about Grandpa and the law. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Connie Glass with the Elder Law Firm in Huntsville, 256-536-9494. Also check out elderlawfirm.net. Here's how to get in touch with Michael Timberlake with Timberlake & League in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way, and one of them will be on the midday news tomorrow. And I practice family law, divorce, child custody, 256-539-7337. Also check out SharonFamilyLaw.com. Connie, okay, I know you can't file your will in advance at the courthouse in the state of Alabama. If you revoke a power of attorney, should you file something about that?
If your power of attorney has been recorded, absolutely. The most important thing is to be sure that the person that you've named as agent knows that the power of attorney has been revoked. So that needs to be sent to that person, and it needs to be given to any place that they've used it, a bank, a brokerage firm, anywhere that they've used that power of attorney. Be sure they get a copy of the revocation.
Okay, last thing, somebody called in, wants to know, do adult children inherit your debt? If
your debt is, your estate is liable for the debt. They're not personally liable, but
Gotcha.
Your estate is liable.
So many questions. So many
absolutely.
brings up good ones. Thanks for all your calls and questions tonight. We'll see you next week. Next week we're going to be talking about, I saw it earlier, fighting the insurance company. Thanks. Have a good week.